Welcome to Benson on Injury Law.
Hey, you too. Thanks, Kevin. Sure. So we call that comparative fault. Now, Wisconsin is what's called a modified comparative fault state. What that means is you do subtract that percentage from your damages. So the jury is given kind of a math problem at the end of a case, and they're asked to fill out a percentage fault for each person involved, and then an amount of damages. And that's what they're asked to do. They're actually not asked to do that calculation. It's a strange thing in the law is that the jury doesn't get to know the effect of their verdict. I think it's very unfair. So the jury sometimes thinks they're giving you $1 million, but they put 60% fault on your client. And then in that situation, your client wouldn't get anything. But like the situation you're talking about, as long as you are less than 50% at fault, then you can still absolutely make a recovery. Your damages are just going to be reduced by that percentage, but you can still absolutely bring a claim. Yes, comparative negligence. Yep, correct. So we're not unique, but there's only a few states like us where if you are more than 50% at fault then or 50% negligent, then you cannot make an injury claim. So, that's why it's really important to get us involved, because the insurance companies will always try to argue that you are more than 50% negligent. I have seen cases where someone gets rear-ended and the insurance company tries to say, well, you could have avoided it. Why did you not look in your rearview mirror and try to move out of the way? So that is a tactic that they are using, in my opinion, more and more to try to pay less on injury claims, especially in motor vehicle accidents. That's why I really see this becoming more popular among the insurance companies. It's very true. It is more of an art than a science, and at the end of the day, it's going to be a jury of 12 of your peers who have to decide on a number. So again, that's why it's so important for us to get involved early. Some of that really crucial evidence that we can use to prove the other party was negligent disappears rather quickly. The most important one is any newer vehicle has something called a vehicle recorder data box inside of it that records crash data. So we can find out how fast they were going, whether they were using their blinker, when they hit their brake, things like that. But that data goes away once that car is totaled and salvaged somewhere. So if we can get involved quickly, I can have an engineer go download that data and hopefully get that percentage more on our side. So that's something that, again, but we need to get involved right away so that we can go get that evidence. Well, same thing. I think they try to use it to bully you into taking less money. They try to say, we think that we're going to be able to prove that you were 20% at fault, 30% at fault, 50% at fault. And they'll try to use that as a tactic to get you to accept less money. And sometimes it can seem completely outlandish and frivolous, their arguments. But if you don't have a lawyer on your side, they won't back down. They're going to stick to that and say you should have avoided this accident. Again, they'll say, "Yeah, we were negligent, but you could have avoided it, and you didn't. You didn't. So we're going to put some fault on you." I think the first thing is, again, we just change that paradigm that the insurance company is no longer in control and they have to prove that. If they want to make those arguments, we put them to their proof and say, prove it. Number two, we can go get that evidence like we talked about. A lot of times that's interviewing witnesses, but it's often getting that vehicle recorder data. And then if this happened, let's say on a busy commercial intersection, there's often surveillance video footage, maybe from a nearby business that we can go get. Again, that footage is normally erased sometimes as quickly as after only a few days. So we can go get that evidence to help prove our case. The other big thing we can do is take depositions. So, we can subpoena that other driver or other witnesses to show up, and we can ask them questions under oath. And that has a way of clarifying these arguments. And often we can prevail and even get 100% negligence on the other driver after we go through that process. But until we're involved and we can file a lawsuit and issue those notices of depositions, issue those subpoenas, we can't do those things that we need to prove the case.
So Paul, walk me through the process, because you're representing them. You're wondering about the percentages. You and insurance companies have different ideas about the percentages. Do you guys, sit down and sort of a mediation trying to work it out? And if you can't, then it goes to a jury. Kind of how does that process work?
Eventually, a lot goes into it before then. Often the first step is we're sending out preservation letters to try to make sure evidence doesn't get destroyed. So that means keeping that vehicle recorder data, making sure that doesn't get destroyed, and then trying to see if there's any surveillance footage in the area and making sure that gets kept. And then sometimes, the police officers might have had body cam footage or things like that. So it's really a quick hustle to make sure that we are preserving all of the evidence before any of that evidence gets lost. That's the most important thing. After that, a lot of times we are trading arguments, and often that does get resolved in a mediation. And what a mediation is that's in the context of we've already filed a lawsuit. We've probably already taken depositions, meaning we've asked both drivers questions under oath. And now we're going to try to get together and find common ground. So we hire a mediator, which is often a retired lawyer, or judge, or someone like that. And we try to settle the case. And we make those arguments to the mediator on those percentages of fault all the time. My goal, of course, is to always try to get 100% negligence or fault on that other driver by using that evidence that we talked about early on, with the big ones being that vehicle recorder data, the surveillance footage, and deposition testimony from the other driver.
So if you still can't agree, then it goes to a jury trial?
Most of the time. If the case doesn't settle at mediation, then yes, oftentimes that case is going to go to a trial. And then it's up to like I said, here in Rock County or anywhere in Wisconsin, it's normally a jury of 12 of your peers.
Okay. Yeah. So, and then is it just up to them to decide the percentages? Is that kind of how it works?
It is up to them. And that's an interesting process, how the sausage is made. Every jury is different. But
Sure.
Yes, that's what they are tasked to do. Getting back to that comparative negligence, they actually are not allowed to know that 50% rule. So we don't get to tell them that if they find more than 50% fault on the plaintiff, on the injured person, that means that person gets zero. Again, I think it's a very unfair part of the law, but it's just the reality is they don't get to know that when they're back there making that decision.
And I would imagine that's not something that's common knowledge for people. I mean, if I'm not sitting here talking to you, I don't know that. So that's not something that most people would know.
Yeah. Yes. I think it's unfair. I think it's patronizing to the jury that they couldn't be trusted with that information, but that's what our Supreme Court has decided.
Are there times where someone comes to your office, sits down with you, and you're kind of like, look, man, you're really at fault here. I don't think you have a case. Does that happen sometimes?
Yep. And I'll be upfront with you. I'm not going to string you along if I think you don't have a case. Absolutely. That's sometimes, unfortunately, what we have to tell people is, we don't think we've got a case here because of these reasons. A lot of times we're still going to do our due diligence. We're still going to go see if there's something that we're missing. Maybe the other driver was going 80 miles an hour in a 25 zone. So even though the other person had the right of way, they were going so fast, our client, the injured person, didn't really have a fair chance. So there's things like that sometimes that the injured person might not even be aware of. So we'll still do our due diligence in a lot of cases and make sure that we're not leaving anything out there.
And flip side of that, I'd imagine there are times where people might come to you and be like, I figured I'd talk to you, but I don't think I have a case. And you're like, actually, you do have a case.
Yes, that happens quite often. Or other lawyers have told them they don't have a case.
Yeah.
I mean, we have resolved so many cases where other lawyers, especially lawyers who probably just dabble in personal injury, might think that there's no case. Maybe they handled your will or something like that. Nothing wrong with people like that, but they're not as experienced and trained at looking at every angle like we are. They just don't have the experience. So a lot of times those cases come to us after supposedly they've been told there's no claim, and we're able to get a good recovery for them.
Okay. Yeah. I mean, yeah, you've seen it all at this point. You've been in the weeds, so you know what to expect.
Yep. We handle almost 100 cases a year, and I've been doing this for 15 years. So, I've handled almost every type of injury claim at this point. I mean, there's always new things, but we've handled quite a few different situations.
So when someone might say, it's like I just said, a lot of people don't know that law, that the 50% thing. So, do you think there's a lot of times where someone might just not want to talk to a lawyer or not want to speak up because they're just like, well, I'll just let the process do what it does?
Yeah, and I think the insurance company is pretty good at making you feel defeated. They're pretty good about telling you that they are the law, like they are, judge, jury, and executioner. They're pretty good at making you believe that, and it's too bad because people are losing out on their legal rights because of something that an insurance adjuster said, who has no legal authority whatsoever.
Do they ever do the right thing right out the gate? Like, do you had experiences where insurance companies are like, oh yeah, my guy is super at fault, we'll take care of this, or anything like that? Or does that not really happen?
Not often, but yes, sometimes they'll admit fault. And a lot of times what they'll do is just fight on the damages side. In other words, how much money we're going to pay you. The value of, a person's pain and suffering is where we always disagree. Insurance companies never put much value on those things that are more intangible. Anxiety, fear of driving, things like that. They just don't value things they can't see.
Mm-hmm. Yeah, they want that data in front of them, the doctor's reports and all that the broken bone, that they can see the X-ray and stuff.
Yep. They are more willing to pay on claims like that. So, brain injury and back injury claims are ones that we're often are harder, where we can actually provide more value for our clients, because often with a brain injury, it doesn't show up on a scan. It really doesn't, because it's not like they do an MRI right after the accident in every concussion case. So often we have no medical hard evidence of their injury other than just their own subjective complaints to their doctor. So those are cases where they're hard, but we can really make a big difference for our clients.
So if let's say I'm in an accident and I'm 25% at fault, do you come up with a number for damages and then I get a certain percentage of that amount? Is that how it works?
If it went to a jury trial, yes. When we're talking settlement, a lot of times those numbers aren't put explicitly down. We're kind of negotiating all of the things kind of lumped into one, normally in one offer. So a lot of times they're not going to say, in the context of like an informal settlement discussion, or even in a mediation, they're not going to say $100,000 but 75% at fault. That's just not how it works. We're just going to trade whole numbers back and forth, making those arguments.
You brought up the brain injuries. I think that's in kind of an interesting little side there I'd like to ask you about, and maybe we'll talk about this more in the future, but there's more emphasis put on brain injuries. Sports like football have brought a lot of it more into the mainstream consciousness and media. Do you see a shift at all, or are insurance companies fighting them just as much as they always have?
I think they're fighting them just as much as they always have. I really do. But I have seen that I think juries are more open to people's brain injury claims. They understand that just because I can't see it, I can't see your injury in front of me, it doesn't mean it isn't there. Whereas I think 10 or 15 years ago, I think it was harder. I think that juries, were more skeptical of brain injury claims. But I think that's becoming less true. So it's even more reason, I think, to hire a law firm, because I think we can make a difference there, because there is just a misalignment between how the insurance company is valuing these cases and how the community is.
That's an interesting point, that the insurance companies in the community aren't necessarily in line with how they look at certain injuries, particularly brain injuries or even just emotional PTSD type, injuries.
Yep, those are the big ones. I mean, PTSD is one that they really don't value, that they really will say, prove it. They really
Mhm.
are, in my opinion, are operating on bad old data where juries used to maybe not value those claims as much. I think a lot, this is a whole nother topic, but I think a lot changed after COVID. I think people's whole view on life and world changed after COVID. And we have
Yeah.
seen juries be more susceptible to those kinds of damages claims than they were before. And that's across the country.
That's interesting that it's that since COVID. That's really, really interesting. Like people are valuing
Yeah,
mental illness, or just mental issues, like just depression or whatever. Yeah,
I think so. We all went through a lot, you know,
we sure did.
we all went through different things, but everyone went through a lot during that period for one reason or the other. And I think that shared experience, I think, of course, it changed us. There's going to have to be a lot of studies done, but anecdotally, talking to lawyers all over the country, yes, we have seen juries more susceptible to those kinds of damage claims post 2021.
Hmm. That's so interesting. I never would have thought of that, but it makes
Yeah.
sense. Makes sense. Real quick, just to kind of wrap up our conversation, I'm curious about the comparative fault. Obviously, it's not always easy to figure that out. So if two drivers are saying complete opposite things of how it happened, if camera footage is low, if witnesses are low, like, does it just become kind of a he said, she said, or are there still ways that you can kind of narrow that in?
Um, it is. You know what's fascinating is I think that a lot of times the insurance company will maintain that position that they're not at fault. They'll be saying their driver says they're not at fault, and then you take the other driver's deposition, and their house of cards often falls apart. In
Mm,
fact, a lot of times it seems like their lawyers haven't even talked to their driver about their theory of this case. And I have had many cases where I just ask them, do you believe you're at fault? And they'll say, yeah, I've never maintained that I wasn't at fault. And that happens a lot. But unless you're willing to do the work, and I do think, again, I think there are some law firms that do more work than others, but unless you're willing to do that work and take those depositions and go through that process, you might not get there. But I do see a lot of times the insurance companies, they're really not representing the best interest of their own driver. If they were, they wouldn't put them through a deposition. They
yeah.
would just settle the case. But they're hoping that we won't call their bluff and we won't go all the way through with it and get them on the record.
Interesting stuff for sure. All right. Well, thanks for listening to Benson on Injury Law. If you've been hurt in a crash and aren't sure whether you have a case, don't assume you're out of options. As we talked about earlier, you never know, and Paul can help you determine that. Visit paulbensonlawfirm.com to schedule a free consultation. Get the answers you need. Be sure to subscribe to our channel. Leave us a review. We very much appreciate you checking out our videos. Paul, I very much appreciate your time. I really enjoyed our chat. Thanks so much.
Thanks, Kevin. Have a good day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.